Supreme Court of India Naushey Ali and Ors vs State of Uttar Pradesh and others decided on February 11, 2025 Manu/SC/0191/2025 facts of the case. On August 27, 1991, case was registered by Abdul Latif, on behalf of Respondent Number 2, the FIR under Section 147, 148, 149, 307, 325, 506, 323 and 504 IPC was registered against all 8 persons, including the appellants, on September 7, 1991. After investigation, the police filed a final stating that the complaint was a false complaint. The police report was rejected. Magistrate, who summoned the appellants and the 3 others, for trial, for offences and issued warrants. The criminal revision was dismissed, due to the intervention of the elderly persons in the village. On December 19, 2022, a compromise was entered into between the injured Mahmood and the appellants. The High Court held that the matter cannot be compounded. Findings of the court: the only question that arises for consideration is the present case a fit case where proceeding could be quashed, particularly when Section 307 Indian Penal Code has inter alia been invoked in the summons. At the outset, we want to set right the error that occurs in the short order of the High Court. The High Court has not appreciated the difference between compounding of an offence and quashment of proceedings. Will the mere mention of Section 307 Indian Penal Code in the criminal proceedings force the court to adopt a hands-off approach when parties come forward with a settlement? In that event, what should be the duty of the court, and what are the tests to be applied to decide in which cases settlements would be accepted and in which cases it would not be? It would be open for the court to examine as to whether incorporation of Section 307 Indian Penal Code is there for the sake of it or whether there is evidence to back it. The courts may go by the nature of injuries sustained, as to whether the injuries are inflicted on the vital/delicate parts of the body and the nature of weapon used. Such an exercise would be permissible after investigation and filing of charge sheet/framing of charges or during the trial. Coming to the facts of the case, admittedly, there is a settlement between the parties. The case filed by the appellant's party, which was prior in point of time and that too on the same day of occurrence, has been settled. It should be recalled that, at the outset, after investigation, the police actually closed the case in its final report of September 7, 1991. It was the trial court, which by its order of September 5, 1992, refused to accept the same and summoned the appellants. The incident is of August 11, 1991, i.e. about 33.5 years back. No doubt, there is a reference to the firing in the FIR, but admittedly there was no injury. The allegation is that firing was done by Abdul Waris. He is since deceased. The facts, assuming to be true, also do not make out a case of common object for the appellants under Section 149 Indian Penal Code insofar as the offence of Section 307 is concerned. The role attributed to the 7 members, including the 5 appellants, is not specific. General allegation was that they abused in filthy language and assaulted Mahmood with lati and iron bars. The specific individual role was only attributed to Abdul Waris, who is since deceased. In any event, the police who investigated disbelieved the entire story. No recoveries have been made of any pellets. What engaged the attention of the High Court was only the fracture of the head of the distal phalanx of left finger of Respondent Number 2, injury with lathis or iron bar. Considering the injury and the nature of the weapon used, certainly no offence under Section 307 Indian Penal Code is made out at the highest. The offence alleged could be one under Section 326 of Indian Penal Code. Considering the special features of the case and taking the settlement on record and applying the law, we are inclined to invoke powers under Article 142 and quash the criminal proceedings. We allow the appeal.